Hi everyone, and thanks for joining us for today's discussion. Today we have Jocelyn Samuels, Director of the HHS Office of Civil Rights, and Lucia Savage, Chief Privacy Officer at ONC. And they're going to be interviewed by Ballew, CEO Aptible. There's going to be some time at the end for open Q&A, so if you're interested in asking a question, please use the Q&A app on the Hangout window, or simply just ask your question on the Hangout event page in the comments, and we'll try to get it answered. I also wanted to note that you can contact Lucia and Jocelyn with further questions on Twitter using @HHSOCR and @SavageLucia. Both of those are going to be posted on the Hangout page as well, so you don't have to memorize them. And with that, I'll let Chaz introduce himself and kick things off. Go ahead, Chaz.
Okay, great. Thank you. So what we'll do today is we'll have very short introductions and then an opportunity for both Jocelyn and Lucia to briefly introduce the portion of HHS that they oversee and a description of the activities and authorities for those offices. And then we'll move to prepared questions that I'll ask, and then we'll move to open questions. So with that, I have a very short opening statement, which is just to recap where we are. So healthcare is one of the largest sectors of the economy. In 2013, Centers for Medicare and Medicaid Services estimated healthcare spending at almost $3 trillion, $2.9 trillion. And at the same time, the U.S. consistently lags in rankings of healthcare quality and access compared to other developed nations. Separately, cloud computing has become ubiquitous in the last decade. It's cheap, it's fast, and it's introduced new opportunities for entrepreneurs in digital health. Rock Health estimates that venture funding in digital health topped $4 billion last year, which is 4 times what it was just in 2011. So we have a massive sector of the economy with some very big inefficiencies, increasingly moving online and being aggressively funded by technology disruptors. So with that, I'm going to introduce Jocelyn Samuels, who is the Director of the Office of Civil Rights at HHS. Jocelyn.
Well, thank you so much, Chaz, and I'm so delighted to be here with all of you today, and my very good friend and colleague, Lucia Savage, who's the Chief Privacy Officer at ONC. I think this is a really valuable opportunity, and I hope will be one of many for us to give you information about some of the things that we're working on, but equally importantly, for us to hear from you about issues that you are confronting and challenges in which you think we can be of help. I know that all of you are active in really advancing delivery system reform, coming up with technologies that have huge promise for medical outcomes, patient treatment, patient engagement in their own health care. And those are invaluable services that we want to be able to promote. At the same time, I know that we all share a commitment to ensuring the privacy and security of patients' health information. And I think it's by working together and continuing a dialogue about the challenges you face in this space, the questions that you have, and the ways in which we at OCR can help to provide guidance, technical assistance, and standards that will enable you and us together to achieve the best health outcomes while ensuring privacy and security. So just to make sure that everyone knows about OCR's role and what we do, basically we are the HIPAA enforcers. We have enforcement jurisdiction for the privacy, security, and breach notification rules, and we use a variety of tools in order to be able to ensure that those rules are complied with. So we take complaints. We undertake compliance reviews when we get some indication that there may be compliance concerns. We provide technical assistance and public education. We do guidance, policies, and regulations, and we are launching an audit program that I'll say a little bit more about in a couple minutes. I guess what I'd like to say is I know that people think that there is sometimes a conflict between HIPAA and more broadly between privacy and security regulation and technological development. I don't see it that way. I think, in fact, that we all share the same goal of ensuring that patients can engage in their health care in order to promote the best possible outcomes. For them to feel confident doing that, we all are committed to the idea that their information will be safe and secure. And so I think that we need to work together to ensure that we can realize these dual goals. And there are serious challenges. And again, I hope that we'll hear more from you when we get to the question and answer part about the challenges that you are facing. But obviously, hacking is on the rise. We know about large breaches that have occurred just in the last couple of months, in which hackers have been responsible for threats to millions and millions of health records. That's, of course, not the only way in which information is at risk. We still have a lot of complaints about theft, loss, unauthorized disclosure of information. So those are things that are challenges we all have to face. And some of the ways in which we've done that before are, for example, with regulations and policy. And you all are probably familiar with the regulation that we issued on the omnibus rule. We also issued a rule on the Clinical Laboratories Improvement Act, which improves patient access laboratories. We issued a guidance on HIPAA's application in emergency situations to make sure that covered entities understood their obligations under the rule. We've done work on mental health disclosures. We are going to be working on a host of new guidances, including on cloud computing.
There we go. I think you're back now.
Yeah, we're back.
Right.
Sorry about that. Technical difficulties. Jocelyn, you were saying you were talking about the challenges of cloud computing and a brief overview of OCR's sort of acknowledgement and responsibilities in that area.
Well, I hope it wasn't anything I said that caused the computer to censor me. But in any event, as you can see, there are sometimes technological problems with which we all have to deal. I don't know where I cut out, but basically, we would love to work with you to provide the kind of technical assistance that would be of the greatest use in your efforts to ensure HIPAA compliance and privacy and security of patients' health information. We have many tools available, and I'd be happy to answer questions about those as we move on. But now I'll turn it back to Chaz to introduce Lucia.
That's fantastic. Thank you, Jocelyn. Lucia Savage is the Chief Privacy Officer, the Office of the National Coordinator for Health IT. Lucia, could you tell us about your office and what you do?
Sure. So this office was created actually in the enactment of HITECH, and it has sort of three basic functions. It serves as a subject matter expert on privacy and security in the health information technology space, in particular for the Secretary of Health and Human Services and the rest of the executive branch. It supports the national coordinator in literally that effort, sort of coordinating all of the various stakeholders in the healthcare system who want to build health IT systems, use health IT systems, or take advantage of those systems that are built. And so we have very diverse stakeholders in that universe, which range from physicians in small practices managed by the spouse to large healthcare systems to actually the technology developers, as may be participating today. And then thirdly, we sort of act as a subject matter expert for other federal agencies and Congress as well on things related to health information technology. So that's the basic concept. And then people sort of ask me what I do on a daily basis. So one of the key parts of my whole team, and there's 14 of us, is to really help all of those stakeholders look around the corner to what is coming next. And Jocelyn's office has a very challenging space because they are the regulator for both legacy traditional healthcare systems, like you might experience in an electronic bill from your hospital to your health plan that results in that EOB you don't understand, as well as what is becoming this health information technology infrastructure for traditional healthcare providers. So one of the things we always try to do is make our expertise and our sort of ability to look around the corner available to Jocelyn's team whenever she wants.
We take advantage of it.
That's right, and that's how we sort of got here today at this hangout. But we also try to do that for other agencies as well. So, what is it that the federal agencies who are trying to figure out how to interoperate at a data level with their constituencies need to think about in terms of privacy and security in this environment? And that really means everything from physical security to locks on the doors, and for the small provider's office, don't put your passwords on a sticky on the file cabinet, literally, to what is the latest and greatest efforts we're doing to combat cyber security threats. That's really the gamut of the team. We have 14 people here. We don't write rules that result in regulations about the HIPAA privacy rule. That's squarely in Jocelyn's team's ballpark. But what I will say about that is one of the things we really do is take the rules that exist and help people understand how to what those rules mean in their everyday practice. And that's an ongoing dialogue between OCR and us, but how do we best help people understand what those rules means? And we hope that some of the feedback we get today moves us down that path of better and better understanding for business people. I'm definitely of the philosophy that if you have clear rules, you know exactly what you can and can't do, and it leads to good planning for everybody. Good planning for business people, good expectations for consumers.
Absolutely, thank you. So we'll move to general questions, and the questions are maybe weighted more towards one or the other, but feel free, both of you, to jump in, and hopefully this will be more of a dialogue than just straight question and answers. So both of you mentioned how one of the challenges of the HIPAA faces as a federal regulation regulating the privacy and security of health data is that it applies all the way from very small entities all the way up to some of the largest entities in the healthcare system. It applies to legacy technology in addition to applying to emerging brand new technology that we've never seen before. So Jocelyn, this question is for you. What are OCR's plans for addressing questions and concerns as they come up about emerging technology and new technology?
So thanks, Chaz, and that's an excellent question. I mean, the first thing I'd say, I guess, is that HIPAA is intended to be technology neutral and to apply regardless of format and, of course, size of entity and nature of its operation are things that we consider in looking at what the entity is obligated to do under HIPAA, and we would do that in the new technology space as well. I think we are working very closely with ONC and other stakeholders to ensure that we can provide adequate guidance to tech developers, because we absolutely want to ensure that tech development can make available to people advances in ways that people can get their health information, use it in decision making, provide it to a range of providers in a convenient way, while at the same time protecting privacy and security. One of the things that we are working on that I hope will be up and running very soon is a portal that will enable tech developers in particular to raise questions with us and to identify scenarios that they are facing and to request guidance on particular issues that have arisen as they've been doing their work. So, for example, we will be able to not only take in these questions, but also make them publicly available so that others can weigh in and say, yes, I face a similar kind of issue, or that's something that hasn't occurred to me, but something similar came up a couple of years ago. I think the idea of that is that it will help us to prioritize where the most pressing issues are arising so that we can direct our technical assistance efforts in the most effective way. We obviously can't give advisory opinions on particular sets of facts, but we do want to make sure that everyone understands how the general HIPAA standards apply in different contexts. And so the portal is one way in which we hope to engage in an ongoing dialogue in order to enable us to do that.
So the other way is Jocelyn does take advantage on invitation of some of the ways in which ONC has systematic dialogue with the healthcare IT industry. So, for example, we specifically worked in developing comments on our interoperability roadmap with our privacy and security work group to use that vehicle and those experts and that participation method to identify things we could then hand off to Jocelyn as here's some things that people in that group thought guidance might be useful on. And one of the things we try to do in that capacity is sort of just as Jocelyn alluded to, help categorize and put things in buckets so that what results at the end of the day is something generalizable to the entire industry and not unique to a particular organization's circumstances.
I guess the other thing I would add to that is only that we are also happy to engage in outreach. We participate in many conferences. We do Google Hangouts. We try to reach out to stakeholders in ways that are beneficial. So if there are ways in which you in the audience would benefit from having someone from OCR come to provide information, remarks, or technical assistance, we'd be happy to do that. And if there are other entities in the technology space, venture capitalists or other kinds of funders, who need to have a better understanding of the application of the HIPAA standards, that's the kind of outreach that we're capable of performing and that we'd be happy to do in an effort to ensure that everyone understands the rules.
What is the what's the best way? So I heard three things: portal, an information portal. Can you elaborate a little bit on will that look like? So again, submitting questions, and then it will be like an FAQ. The questions will come back, possibly parsed.
We are still developing that, and should anyone in the audience have ideas for it, I'd be delighted to hear it. But I think that it is intended to be an easy and convenient way for people to let us know what questions they have, and then to try to crowdsource those a little bit so that we can identify those that are coming up frequently and direct our guidance efforts that way. Okay. Sometimes that guidance can come in the form of formal policy documents that we release and disseminate. Sometimes it may come in informal advice that we give on the telephone or through outreach engagements. But I think that enabling us to really identify the issues that are arising on the ground will be very helpful in enabling us to structure our responses.
Okay.
But Chaz, if I could just add one thing, the important thing to keep in mind is that all this takes a very methodical and analytic process to get it right. So, and there, as Jocelyn said, there are already things in queue: cloud computing, accounting for disclosures. There's a whole long list of things that are on the OCR task plan, as there are at ONC. And we're human. We can't do everything at once.
Well, I can't.
Yes,
Lucia, on the other
no,
hand.
there are no super women here, as much as we would like to pretend. So people have to have a measure of recognition that there's a process, and we have to go through that process to make. We don't want to say anything that is going to lead someone astray.
Certainly, and you had mentioned in addition, so structured input through a developer, a portal for anyone. Working groups, Lucia, you mentioned specific targeted outreach by HHS on an outgoing basis. And then Jocelyn, you mentioned HHS's willingness to engage with stakeholders. What's the best way for that last part that you mentioned? What's the best way for people to get in touch with HHS to even request something like that?
You know, you should come to our website. There is a general OCR information box, and people can definitely file emails in that way. We also have a 800 number that people can call. I would say if people want to get in touch with me directly, that is also fine. The format of all HHS emails is firstname.lastname@hhs.gov.
Interesting, Chaz, there's actually a public email directory on the hhs.gov main website. You just have to look for it in the upper right, and you can search for anyone's name, and their email and their office phone number will pop right up.
Okay. That's
so we
great.
all get calls, random cold calls from the public. The other thing I'd say is, so for at healthit.gov, which is the ONC website, we have, you can use that tool to request people to come and make presentations. You can search in various ways for different materials, and I think that today, I don't know exactly how it works because I'm not a Google Plus expert, but I think Maya has actually already put up some links of various materials that OCR has published or that we have published that we think have helpful background information about the HIPAA privacy and security rules in them. And then through ONC, of course, it always has its work groups and various volunteer activities where people can come and get involved in the everyday work that ONC does.
And the last thing I'd add on this is just we do have 10 regional offices around the country. And so while I'm in Washington along with members of our headquarters staff, we have people in Seattle, in San Francisco, in Dallas, in Denver, in Boston, in New York, etc. And so to the extent that those of you listening today are located in a city in which we have an office, it's very easy to have in-person contact with people on our staff.
Okay, great. Thank you both. Those are fantastic resources. So hhs.gov, healthit.gov, and we have email directories. There may soon be a portal for submitting questions to HHS online as well. Okay, I'd like to move to a couple questions, more specific questions about technology. We know that you've mentioned several times that HHS is contemplating guidance regarding cloud service providers. And what are can you elaborate a little bit more on possibly the scope of the guidance, potential scope, topics that might be addressed, things like clarifying standards for encryption, encrypting data, managing keys, encryption keys for protected health information in the cloud?
So sure, and this is something that we recognize there's a significant demand for, and understandably, because the cloud is obviously a new technology that is being increasingly used in the healthcare space. We will be issuing guidance on cloud computing. We anticipate that it will address obligations of both covered entities and business associates to ensure that they comply with the HIPAA security rule and use and disclose protected information only consistent with the privacy rule and with their business associate agreement. I anticipate that we will address the use of encryption as a means of protecting data on the cloud. I will say, and I think there is nothing inherently more or less secure about the cloud than other means of data storage. It all depends on the kinds of measures that covered entities and business associates take in order to ensure protection of privacy and security. So I think that it's not the medium, it's the care that the entities responsible for the data storage take that will dictate whether or not they are providing adequate protections. That said, encryption is a wonderful tool and one that we generally either require entities to explain why they can't do it and what an alternate effective standard would be. But it may not alone be sufficient to provide the kinds of protections for privacy and security that are going to be necessary, and encryption certainly doesn't address access issues, which is something that is obviously a very important additional component of the HIPAA rules.
I defer to her on that. It's her role.
Can you speak to a little bit? So we've had you also mentioned prior we've seen several high-profile breaches in the news lately, or the Anthem breach, which could affect up to 80 million people, individuals, and then the Premera Blue Cross breach, which is a smaller breach, at only 11 million individuals, but is suspected to actually contain actual medical information. These are medical records, whereas the Anthem breach is personally identifiable information, but may not be full medical records, for example. So these are the scale is breathtaking. Can you, Jocelyn, can you talk a little bit about, with regards specifically to encryption, what does HIPAA have to say about encryption, and how does, when thinking about encryption and thinking about breaches and PHI, what are some considerations? What are some broad strokes to consider?
So, I mean, as folks listening probably know, encryption is an addressable standard under the security rule, which means that entities must implement it if, through their risk analyses, they determine that encryption is a reasonable and appropriate safeguard that's necessary to secure electronic protected health information. If it's not reasonable and appropriate, then the entity has to document that and come up with another effective alternative to provide the kind of security and privacy protections that the rules require. There's an incentive to encrypt as a means of ensuring privacy and security protections, because, as you are all probably aware, the breach notification rule creates a safe harbor for encrypted data. So if it is unsecured PHI, then we have to be notified every time that there is a breach. If it is encrypted, that takes it out of the realm of the breach notification. And so as long as the encryption is done consistent with NIST standards and the keys are kept separate so that there isn't the possibility that the encrypted data can be unencrypted in a harmful way that involves malfeasance, then that gives you some protection against the obligations of the breach notification rule. So I think that there are many good reasons, both as a matter of policy and of law under the breach notification rule, that it's advisable for entities to encrypt data to the extent that they can. Now, we've heard that there may be problems with encryption and that using encryption may limit accessibility or manipulability of the data, and that's one of the things on which we'd love to get some input from folks out in the field, because we'd like to understand more about the barriers posed by encryption so that we can evaluate whether there are alternative means or whether there are ways that access can be alternatively provided that would enable the data to remain encrypted while the covered entity satisfies its access obligations.
Can we ask a quick follow-up question too? We heard there's encryption and then there's de-identification. What is the difference between the two? Is there, in terms of relevancy?
So encryption is a way of, just to put it bluntly, and we have a really great explanation of this actually in our new privacy and security guide, which we did with Jocelyn's team that I think Maya sent the link out to. for lack of a better way, it literally takes something that's normal, a normal string that would be understandable to the human eye, and hashes it in a way that can only be unhashed with the key. De-identification is a different thing entirely. It's removing data points to take any of the 18 individual identifiers out of the data set. So HIPAA has a standard of 2 ways of de-identifying. One is remove 18 data points. The other is have a statistician certify it as very low likelihood of re-identification, but essentially take out of the data so that it's no longer in use things that are specifically in the regulations defined as identifying of patients: names, addresses, birth dates, social security numbers, biometrics like a fingerprint or a fingerprint or an iris scan. There's a whole long list. You can open up the book and read it.
So when you have a data set and you remove identifiers, you de-identify that, or you have a statistician assert that data set is no longer PHI.
Correct. De-identified data is not subject to the same rules that PHI is subject to.
Is that different? And then encrypted PHI, on the other hand, is still...
It's still PHI. It's encrypted as a security measure, as opposed to as a way of rendering it information that doesn't need privacy protection.
Unusable. Thank you for clarifying. I want to make sure that everyone who's listening in the Google Hangout remembers that you can submit questions that we can ask as follow-ups on the, I believe, in the left-hand side of the Hangout window. You can submit your own questions, and we'll get to those probably in about 10 or 15 minutes. So go ahead and submit those now. Okay, here's a question for both of you. How we have the enforcers, the Office of Civil Rights, and the coordinators in ONC. How do you ensure that both of your offices stay coordinated?
Well, I'll sort of go first to give an example of how we work with Jocelyn's team. So, for example, our Privacy and Security Guide, which was published, I want to say 3 Mondays ago now, right on the eve of HIMSS. We take a pretty significant lift in drafting the actual document based on our team's knowledge of HIPAA. We have a lot of HIPAA experts working right here in ONC. And then we ask for Jocelyn's team to give it, actually it's about 4 times over, but the once over. So they go through it and help us make corrections, and then that goes through a very official process so that all of HHS can stand behind what we then publish on our website. And so we actually have other agencies also weigh in on that process. So when we publish an official document like the guide, that is the normal process, and it's very painstaking. I think the guide from beginning to end took us 8 months, drafting, redrafting again, getting input from Jocelyn's team and other relevant HHS agencies, and then finally publishing it on April 10th.
So what I would add to this is I don't know if she would think of this as a good thing or a bad thing, but I spend more time with Lucia than I do with my husband, which is a testament to our level of collaboration. But I would say the process that she's just described also relates to something that she said a few minutes ago, which is that we have a queue of guidance issues and policy documents that we would love to be able to issue. But because when we issue a document as an OCR product, it represents a consensus position by the government as a whole, it takes a while to ensure that all of the government offices with equities in the subject are comfortable with the positions that we've taken. We collaborate extensively with ONC on an informal basis before we even commit things to paper. And we also brainstorm about issues that we've heard about, keep each other informed about what we're hearing on the ground, talk about kinds of solutions that might be possible. I would say that informal collaboration is exceptionally valuable because it helps us to structure our thinking when we do get around to producing written documents. But when there are written documents, it is a process that takes considerable time, but I think in the end is worth it because it really does mean that stakeholders can rely on what we say as the position of the United States government and not just of a single office within the government.
And then, Chaz, if you don't mind, just to give a couple more examples historical of a collaboration with OCR. So we actually started in 2013. I think it was published in early 2014 to offer up for the users of the universe a model notice of privacy practices. It takes two forms. One is plain language PDF that, for example, a physician or a small health plan might download. I think that's had 250,000 hits on OCR's website, very successful effort. And then we took the same content and had it programmed into an HTML document that developers can download and use in that format to include the content in whatever privacy notice they need to include, say, for example, in an app, and that's available on our website. It's also, both have been linked in the Apple Health Kit, so when you're working on an app that interoperates with Apple Health Kit, you will be given those links as a resource for you as a developer.
We also, speaking of the model notice of privacy practices, we also have it available in other languages.
Yep.
And so to the extent that you deal with people who are of limited English proficiency, those can be useful to you as well. And I would say Lucia is absolutely right that the model notice is an example of a successful, very successful collaboration with ONC. It is also an example, if it has been downloaded 250,000 times from our website, of extraordinary success that you in the field have had in negotiating our website, which I am happy to report will be enjoying an upgrade this year. Our website is a product of the 20th century, and we are updating and revamping it, and I hope it will become a more user-friendly, more accessible, and more useful tool in the future.
That's great. So hhs.gov, is it due for a refresh?
/OCR.
Okay. So you mentioned that if a company, this model notice of privacy practices, if a company or developer is wondering what a notice of privacy practices should look like, that's a resource that they can look for and get a good example for that, which is great. So
Correct.
If you're developing terms of service or privacy notices, privacy policies, this is a resource that's available. You can go access that. And we
also, sorry to interrupt. I mean, we have many other resources, including videos that will walk providers through their obligations, various other curricula that people can use, other sample documents that walk people through different requirements of the privacy and security rules. So our website is chock full of valuable information that will soon be easy to find.
Great, thank you. Going back to technology, entrepreneurialism, and business associates, we know that not everyone who deals with health data is necessarily regulated by HIPAA. There are some requirements, and sometimes the definitions can be nuanced. But if you are regulated, you may be a covered entity or a business associate, or somehow regulated. Based on your experience in enforcing the rules, what are some of common issues that you see both with business associates in general and with technology-specific business associates, or business associates who are providing technology services in the cloud or otherwise?
So I guess the first thing I'd say is, under high-tech, for the first time, business associates became directly liable for violations of the privacy and security rules, and they're also obligated to comply with the breach notification rules. And so, yeah, although there were ways that they could be held accountable before, OCR now has authority to enforce those rules where they are violated by business associates. We want to be able to provide additional guidance specifically to business associates about their obligations, but in the interim, all of the guidance that we have that's applicable to covered entities is a very good place to start for that information. And frankly, we see the same kinds of issues arising in the business associate community that we do in the covered entity arena as well. So whether it is inadequate risk analyses or a failure to adopt a risk management plan that addresses all of the vulnerabilities that have been identified in the risk analyses, whether it is a lack of security and control over mobile devices, or improper disposal of PHI, or unauthorized access or lack of physical controls. Those are all issues that have arisen for all entities covered by HIPAA, whether they are health plans, providers, business associates, or others. So that's, I guess, you know, when I talked about what is typically included in our corrective action plans in agreements with entities with whom we reach resolution agreements, conducting a comprehensive risk analysis is the first step that is really critical, because it enables an entity, whether it's a covered entity or a business associate, to really thoughtfully identify the risks and vulnerabilities to PHI that are specific to its own environment, and then to customize the steps that it takes to address those risks and vulnerabilities. So that's sort of the cornerstone of what every entity ought to be doing.
And if I could just add, you know, within the ONC universe, because the meaningful use rules require a provider who's going to be a meaningful user to attest to having done a security risk assessment, as is required by HIPAA, we actually have a security risk assessment tool on the ONC website. Again, the audience, a primary audience for ONC, is small and medium-sized provider organizations who may lack the resources to hire consultants to do this for them. So we create some tools, but we have a great security risk assessment tool. It seems to be not quite as popular as that Notice of Privacy Practices, but it's inching up there in the hits. And
we'll put it on our website.
Oh, great.
That'll get
I think you already have a link on the OCR website to it, but it's something that a provider can use in their office to identify for themselves as a covered entity, or that provider's business associate. Might be a small developer in the community who's a business associate, to do the risk assessment that in fact is required.
Okay, thank you. So one last question from me, and then we're going to turn it over to audience questions. The question I want to ask is about access to information. So you're both have spoken in the past about the fact that patients' access to their own health information is a fundamental right, is important under HIPAA, and that HIPAA is designed to facilitate access. So the question is a two-part question. Number one, what are some of the ways in which you see and would like to encourage both business associates and entities regulated under HIPAA to provide patient access, and what are some of the ways that they can do that? And the second portion is what do you see emerging, and do you have any either pluses or minuses, any thumbs up or thumbs down, any concerns or sort of, I don't know, again, thumbs up you would give?
Well, I'll start by saying patient access is both the law and good policy. So you're absolutely right that the HIPAA rules require patient access, and there is a lot of information on our website about the standards that apply to patient requests for access. But it also is a critical component of the delivery system reform that the department and the government as a whole is looking to implement. Because the more that patients can access their information, the more involved they can be in their healthcare decision making, the more informed they can be about treatment options, the more they can take responsibility for adhering to a treatment regimen. So I think beyond the purely legal obligations, it is a really important component of ensuring that we have the kind of delivery system reform and improved health outcomes that we're all striving for. I would say, again, there is a lot of guidance on our website about the particular standards that govern the access obligations, but I think that it is critical for all covered entities and business associates to recognize that those obligations exist. There are timeframes that apply. Patients can request the format and means by which they'd like to receive the information. Patients can direct a provider to provide the information to another individual. And all of those are important components of ensuring that this is a robust right that really serves its policy purposes, as well as meeting just the actual letter of the law. But Lucia, I think, has just done a report on this very question and can share some lessons learned.
Well, here's what I'll say. You know, ONC did issue its proposed 2015 CERT rule, which has a specific technical concept in there about access, and ONC's regulatory purview is prescribing by regulation what certified EHR technology or certified health IT technology, as we move further into delivery system reform, has to do at a technological level in order to enable the providers who are receiving meaningful use incentives on the Medicare side of the house to receive those incentives. And we have definitely made a proposal about patients using the current view, download, transmit capability in conjunction with application programming interfaces, or APIs, as a way of one method of pursuing their access rights. And people can comment on that. I believe the comment period closes, don't quote me on this, I'm going to say June 1st, but there's about 30 more days left in the comment period, and you can get more information on healthit.gov. But I think I'm with Jocelyn. I'm a patient, and I want to be able to access my data. And it's very frustrating when I go to one provider and I ask them to send a visit summary to another provider, and I'm a privacy professional and I get a big fat I'm not allowed to do that, when I know that the opposite is in fact true. So I do have a personal mission of helping providers and their business associates understand what this access right means, and making sure that patients who want to take advantage of it have the ability to do so, whether it's asking for a printed copy, you know, getting it onto some kind of CD-ROM, but as Jocelyn said, in the medium that they choose, as described in OCR's regulations on this.
All right, thank you. Oh, before we turn it over, one last question. Jocelyn, you mentioned that you wanted to say something about business associate audits. You mentioned, you specifically mentioned.
Well, I think the audit program more broadly, as people probably know, in 2011 and 12, we implemented phase 1 of our audit program. And audits will be, I think, a critical new tool for us, because they'll offer us the opportunity to look at systemic issues before they result in violations or breaches, and to identify the kinds of issues that are affecting different segments of the regulated industry, so that we can better, again, target the kinds of technical assistance that we give. I think the results of phase 1 of our audit program, which were evaluated very rigorously by KPMG in a report that they did, have proved how valuable a tool it is. We are developing phase 2 of the audit, which we anticipate rolling out in the very near future. We do anticipate that the audit will cover different segments of the industry, including covered entities and business associates, and we will be posting details on the protocol and the timeline before we start phase 2 of the program, so stay tuned for that.
Great, thank you. Maya, do we have questions from the audience?
We do. So the first question we have got cut off a little bit, but I think we get the general idea of what it is, and I'll let you guys respond. So it was, I was communicating with a doctor by e-fax, which is faxing notes and specifications from my computer. She, the doctor, I guess, told me I had to print them and get an old type fax machine in order to be compliant with HIPAA. Otherwise, we would each have to get encrypted e-fax technology. So the question's a little bit cut off, but I think the issue is the person's asking, is their provider allowed to do this? And is that really that it's necessary to be in compliance with HIPAA?
So interesting question there. You know, if the provider is using 2014 certified EHR technology, that technology includes as a required technological feature the ability for a provider to set up a secure messaging system with their patients through the patient portal. And so I think that that person should really check in with their doctor, whether that doctor is a meaningful user and whether that doctor is using the portal capabilities. I use my portal all the time. I log on securely. I send a message to my doctor. She sends a message back. it's all consistent with the HIPAA security rule.
And Lucia, this is by portal, you mean like a website, like you log in and you
Right,
go to a website.
Portal that your doctor's EHR has a portal available by if it's certified technology, and you get access rights. Your doctor validates and authenticates you, and you get access rights to your information as you on the portal, and you can, that should have a messaging component in it.
Can you address the case that even if, say, for example, if the doctor didn't have a portal, what the answer would be there, or?
So if patients would like to get their information by email, they are entitled to request that of the provider, and the provider generally is under obligation to agree, not necessarily for access purposes, but for things like appointment reminders or other kinds of communications. One of the things that we find is that some providers are mistakenly using HIPAA as a shield, when in fact it is not. Obviously, strong privacy and security protections are very important, but it is also true that a patient can request access in a variety of formats, and HIPAA itself does not prevent a provider from responding in the way that the patient chooses to receive the information.
The last thing I would say is that you have to, the dynamic is such that there are the obligations of HIPAA sit on the provider as a provider. They don't actually regulate what the patient does. And so the patient can disclose their PHI to whomever they want in whatever format they want in any particular way. And so that's another thing to tease apart in that particular fact pattern is what exactly is the physician's concern. And the physician may indeed have some concerns about security in what they say back to the patient, but that's different than the format the patient supplies communications in.
Does that extend to, so for example, if the patient preferred to email information to a provider, the provider now has in their email account or wherever they have email, they have the responsibility of maintaining the privacy and security of that information. Is that correct?
There are a lot of complexities related to provider emails. Provider may not want to give out an email address because they may not be getting paid to read email. The provider may want to maintain limited inflowing data systems so that they can manage their own work and their own life that really actually kind of have nothing to do with the privacy and security rule of HIPAA itself.
But I think, if the provider, well, let me say first that, of course, the provider has the obligation to protect the data, the PHI that it holds, regardless of how it came into possession of it. If the provider has the data, the HIPAA obligations apply. In general, I think the question would be, has the patient made a reasonable request to receive information from the provider in the format that the patient identifies? The provider can assess whether, under the terms of its risk analysis, disclosing information in that way would pose too many risks to the security of that information. But as a general matter, if a person wants to get information from a provider via email, that's something that's permissible under the rule. And as Lucia notes, of course, there are no HIPAA restrictions on what an individual can share. So if an individual chooses to communicate with her provider by email, then there are no restrictions on her being able to do that.
Great, thank you both so much. So probably have time for about one more question. There tends to be a consensus among patients that patient portals are often hard to navigate and don't easily yield the answers that patients are seeking. Can you clarify some additional communications tools that patients can use with their doctors and with some of these vendor companies outside of logging into a portal or scheduling a visit?
Well, I mean, from the ONC's perspective, what I would say is, since we don't, in general, tell physicians exactly how to practice. That's not how the American system works. Physicians set up their businesses in a way that's meaningful to them. And for me, all I can do is tell my own story. When I had to look for a new physician, I looked for one that would communicate with me in the way that worked for me. It with a portal that worked for me, with various many other things, quality standards and commute patterns and parking and all that stuff. So people are free, they're physicians, and physicians are free to organize what they need to organize to effectively serve their patients.
And I guess, you know, the other thing that I would add is we'd be interested in hearing about ways in which patients would like to be able to communicate and technologies that are available. I don't know if anybody has Google Hangouts with their doctors. I don't know whether people want to use texting mechanisms to do this. The analysis of HIPAA's application in each of these contexts can be complicated, but it's certainly something that we're prepared to take a look at if these are serious issues out in the field.
Great, thank you. And one last question. When does a messaging provider need a business associate agreement? And more importantly, why would they need one?
A messaging provider? You mean a provider sending a message?
I think it's unclear from the question. I think
that may be something. So generally, if you're gonna, this may be like if you're using email, very few of us host our own email servers anymore, or like if you're sending a fax or a text message or something like that, there are other, you might use a service. So under what conditions?
Okay.
So HIPAA has what we have called the conduit rule. It was adopted at a time when people still communicated through the post office, through envelopes with things called stamps. But the idea was that because the post office is technically speaking exposed to PHI by delivering an envelope from a provider addressed to a particular patient, as long as the entity does not maintain the data and is only the incidental deliverer of the information, it does not have HIPAA obligations. That said, if the entity maintains the data for any length of time, that's something that we'd have to take a look at because, again, the conduit exemption was designed for entities that really did just facilitate the delivery of the information, the phone lines, the post office, and so its application to other kinds of entities, SMS systems or things like that, raise complicated issues that I think we'd have to understand more about and that relate to, does the entity store information? If so, for how long? What kind of information is it? And in essence, what's the purpose of their use of the information and what are the limitations that it puts on itself?
A good way to think about it, Chaz, is if you were the person whose data was in that process of transportation and the transporter kept a copy of data about you, would you expect that as a member of the public? And even if you knew it was happening, would you not then expect that custodian to actually keep it safe according to the same standards you thought applied to it at your physician's office?
Okay. Maya, do we have one more, or are we?
Nope, I think we're good. All right, guys.
Thank you both so much for coming in. This is an extraordinary example of government in action. So we have resources. The HHS website is going to be revamped. We have multiple channels of contact available for individuals and businesses and community members to get in touch with HHS. There is more to come on the HHS website, more to come on guidance, more to come on both guidance for building and for audits, for example, for enforcement too. So again, thank you for both taking the time today, and I'll turn it over to Maya.
Thank you very much, Chaz. It's been a pleasure to do this.
Thank you.
Thank you both so much. All right, thanks everyone who joined, and we'll see you next time. Have a great day, everyone.